Okay, here on the record, this is the people of the state of Michigan versus Donovan Ramon Pippins, who is defendant number 9 on case 2355480. Mr. Pippins is charged with count 4, which is police officer assaulting, resisting, and obstructing. Set for a preliminary examination today. Appearances.
Alexander Kerner on behalf of the people, P86280.
Afternoon, Your Honor. Your Honor, Wyatt Harris, P54891, on behalf of Donovan Pippins, who is standing there in the courtroom. I appeal via Zoom.
Attorney Harris, your audio went out. Could you state your appearance again, please?
Afternoon, Your Honor, Wyatt Harris, P54891, on behalf of Donovan Pippins, who appears here in the courtroom. I appeal via Zoom.
No, it's all garbled. Okay. For some reason, your audio is garbled.
Your Honor.
Yes, I can hear you much better now.
Okay, I took my AirPod off. Let me put my appearance again. Wyatt Harris, P54891, on behalf of Donovan Pippins, who appears in the courtroom. I appear via Zoom with the court's permission.
Court's permission. Mr. Pippins, can you state your full name for the record, please?
My name is Donovan Ramon Pippins.
Thank you. Good afternoon. Okay, Attorney Harris, you're on Zoom because is it correct that your client wishes to waive his exam today?
Yes, Your Honor.
Okay. Mr. Pippins, I'm going to ask you a series of questions. If you don't understand my question, please let me know. Also, if you cannot hear it, please let me know. I will repeat your question or explain it to you, okay? And make sure you speak up for your responses for the court.
Okay.
Is it your wish to waive your preliminary exam today?
Yes.
You understand you have a right to a preliminary exam?
Yes.
And if you were to demand that exam today, the prosecutor would have to show that the probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit and that you probably committed that crime. Understand that? And then by waiving your exam today, that means you do not have to show that or prove anything today.
Okay.
Knowing that information, you still wish to waive your exam? Did anyone force you or threaten you to waive your exam? And did anyone promise you anything? No? Did anyone promise you anything for you to waive your exam?
No.
Okay, so I find your waiver to be freely understandable, clearly given. And that's with no objection from the people, correct?
No objection.
Okay, so you are in custody, so I will have you bound over for an arraignment on the information next week, 1 week from today, March 22nd at 9:05 a.m.
29.
I'm sorry, today is 22nd. 29th at 9:05 a.m. Framework knowledge.
I think.
You're welcome. Anything else, Attorney Harris?
Nothing further, Your Honor. Thank you.
Thank you. Oh, Attorney Harris, do I have your permission to sign your name on the waiver form?
Please do, Your Honor.
Thank you. All right, you have a good one.
You too.
Okay, we are on the record, back on the record. This is case 23055-480, Eagle State of Michigan versus Brandon Morrell, who's defendant number 1, Brandon Antoine Cook, defendant number 4, Larry Reginald Coppins, who's defendant number 5, George Lindsay, who's defendant number 6, Cortez Deontay Miller, who's defendant number 7, and Devon Leontay Sutton, who's defendant number 10. Whose attorney is not present as of yet. I guess we'll start with from my left to right for appearances.
And please, this honorable court, Darnell Barton, P 83363 on behalf of Mr. Brandon Morrell.
May it please the court, Attorney Brett Jaffe on behalf of Brandon Cook.
Neighborhood Defender Service by Jackie Polkowitz, PA 1653 on behalf of Larry Toppin.
And Brian Brown, P 805-607 on behalf of Mr. George Lindsay.
Attorney Russ Donaldson, P number 53660. I understand it was the attorney of record for Cortez Miller. I do have his permission to ask the court to take that into account to verify that I can state.
Okay, and if I forget, please remind me. As I stated, Attorney Harris is on his way to representing Mr. Sutton. There are no defendants in the courtroom at the time. I'm allowing it just before the defendants come in to address any preliminary matters, any logistics that need to be discussed before we begin, if we're going to vote today. So, Attorney Cook, you had something to discuss?
Yes, Your Honor. With regard to Mr. Cobbins, Your Honor, I am not in receipt of digital discovery at this time. I have requested it numerous times. There is a video from the Wayne County Jail capturing this entire incident. I don't think I need to go into the fact that, of course, it would be invaluable for the prosecution's case against my client, which, based on these allegations, I can't even see, in addition to impeachment evidence. Judge, I'd like to set out the number of times that I have requested this footage, beginning on February 10th, when we were appointed, continuing at the probable cause conference on February 22nd. I requested it again on March 8th before Your Honor at a probable cause conference. I sent a follow-up email on March 10th. I sent a follow-up email on March 14th, both of these to Omar Shajara and Daniela Perrick with the Wayne County Prosecutor's Office. I sent another email on Friday 17th, again, indicating I still have not received digital discovery. Please send it to me as soon as possible. I received a response from Ms. Perrick on Friday, indicating that I would get a follow-up from APA Crooker. And if I didn't, to follow up again. I followed up on Monday because I did not receive a response from the prosecutor's office. Midday on Monday, the 20th, I received an email from APA Crooker saying our tech support has looked into the issue and determined that in its current format, the video could not be opened. I reached out to the OIC to ask if the video could be uploaded in a different format by the end of today. I have not heard anything back. That was on Monday. Judge, I have asked numerous times. The prosecutor's office is in violation of Michigan Court Rule 6.201F, which requires that the prosecution tender discovery within 21 days of request. My first request was on February 10th, so well beyond the 21 days. Judge, without this evidence, I do not think that I can be effective. I would ask that the court dismiss this case without prejudice, and in the alternative, I would ask the court to allow a further argument, but our request is for a dismissal at this time.
Are there any other attorneys or any other counsel that did not receive digital discovery?
I too have not received discovery and exculpatory evidence in there, seeing nothing through the police reports. And there is no mention of my client actually doing anything substantive that would substantiate these charges. So I would definitely like to see any video, because that could possibly exonerate my client from any wrongdoing of these charges.
And for the record, Attorney Brown.
Yes.
So every time, just for now, please state your name before you begin speaking for the court. Okay, anyone else?
Attorney Jaffe, Your Honor, I also made several requests for the video discovery. I would also submit, as things stand based on the paper discovery, there's not a scintilla of evidence to even remotely implicate my client, or really anybody for that matter. And I would just say, again, I would join in the request for a dismissal. And here's the thing, the fact is, I understand that the Wayne County jail is extremely underfunded and undermanned and everything else, and I'm like aware of that. However, I do know, in my understanding, is that the surveillance system at the Wayne County Jail is pretty high tech, And it doesn't take this long, like, that, it just doesn't, it's untrue. It absolutely does not take this long, it's not rocket science to put this onto a disk drive or something like that. So for those reasons, Your Honor, again, I would join in the dismissal, and again, I've made countless requests as well, I believe as early as Sister Counsel just referenced, more or less, but again, I would join in the dismissal, because again, the paper discovery, it doesn't stand on its own anything. So.
Anyone else?
Yes, Attorney Darnell Barton, for Mr. Brandon Burrell. Again, I would join in Sister Counsel, promotion. I was actually, so I reached out initially when we were appointed to the cases, as well as the fact that I was told there was no video from an APA. So
Which APA?
that was not from Mr. Kirker, that was from Miss Lori Morales Smith, who was dealing with our circuit court case. She was, the information was sent to me, but it was the wrong video. So I replied back to her, hey, there was, this is not the video. And she said, oh, there is no. Are you sure? I said there should be. Obviously, there should be, but we would join in again, you know, in the motion, Your Honor, to dismiss as well.
And I was privy to that same email exchange as well, in terms of the wrong discovery, and then the follow-up by stating that there actually isn't any digital. So.
Your Honor, for Cortez Miller, Attorney Donaldson, I can't say whether or not Mr. Mortimer received the video discovery. I did ask him for the discovery, so I can prepare for today. I was given the written discovery. So I can't say one way or another whether or not I got it, but I will concur with brother and sister defense counsel here that if no one else got it, I would strongly suggest or believe that Mr. Mortimer did not get it as well. And just for some background information, in reviewing the discovery, there are some specific certain defendants out of this group that were particularly named, but it's really a shotgun approach, Your Honor, where they're saying everyone in the block did something, but there's no identification. I think that the video would be important from a constitutional standpoint, having the defense counsel be prepared to either dismiss the case or show cause the prosecutor why it's not been provided.
Response from the people?
Good afternoon, Your Honor. Daniela Parrish, on behalf of people P85495. Co-counsel for AGA, Alex Kirker to my side. I do want to make a couple of observations, and then I will allow AGA Kirker to follow up on some details as he was actively attempting to obtain this video. Yes, I have not received any requests from anyone other than Counsel Phillips at that time. I understand she indicated all the time she reached out. Every time she reached out, our office replied. Unfortunately, and that was Omar, and I was CC'd on that she was sent. However, she is not incorrect in the fact that what was sent to her, however, was not a video, because myself, I attempted to look at it, and it was not a big enough file to be a video. So that's where then this investigation of a video. As Council Barton indicated, I too was told that there is no actual video, because I inquired, I said, I thought this is supposed to be a video. And they said, no, and then we were told, well, there may be video, but not of this incident. So we've been told several different things. We, the people, do not have video in our possession.
Who told you that?
It has been conveyed to me via email from APA Kirker, and then I'll let him obviously give more detail on that. But as of right now, the people do not have video. Therefore, we feel it would be inappropriate to dismiss on the fact of discovery that we, the people, don't even have at this time. I would understand, and I would have no objection if we actually had the discovery and we weren't providing it. That's not the case. We ourselves do not have it, and APA Kirker has been active in trying to get a resolution to get, if nothing else, a reason as to what the problem is. So I will allow APA Kirker to follow up on what he has found.
For the record, Alex Kirker, key number 86282. I spoke with the not the officer in charge, but one of the officers associated with this case for several hours on Monday. He had to actually get into my computer and download items just to try to send it over. The issue is with the type of video that the jail is trying to send, you have to have certain apps downloaded on your computer, and then you had to upload the root files, which were 32 gigabytes. And that is too large to upload to evidence.com to then send over. So the latest that I have from the officer, or one of the officers involved, was that it may have to be manually done through a flash drive, since the file is too big to physically send to us. It's also been my understanding that there's video up from the jail, it's not of this incident per se. However, we're still trying to obtain whatever video is available.
Your Honor, may I respond?
One moment, I'm gonna have Attorney Harris, put his appearance on.
Yes, Judge, good afternoon, Law Harris for Lieutenant Diva and Sutton.
Okay, and just so you know, we've been on the record for about 10 minutes discussing one issue, which is digital discovery, and all counsel has stated that they did not receive or could not open what they were told or believed was digital discovery or video of the incident or video at the jail.
Copy in on that.
Okay, that's what I wanted to know. Okay, so before Ms. Phillips, I want to ask a couple questions for Mr. Kirk. Have you been able to watch the video yourself?
No, just because of, I guess, the format that is, they haven't been able to actually send it over. So the latest solution would possibly have to be manually.
Is the officer in charge here?
The officer in charge is here. I'm not sure if the officer was speaking with on this because it was their tech services over there.
Okay,
So
can somebody speak to?
I can go speak to the officer.
Okay. And I'm going to wait until he comes in, Attorney Phillips.
I appreciate you. As always.
If you all want to sit down, it's fine. Seems like this is gonna be.
We're too amped up. We can't- Chris Sharp tries the best.
Yeah, I was about to say.
We're gonna bring the-
About to do 101.
Insert whatever.
Stretch.
I need
Right, okay, I did see that.
Oh.
Yeah, yeah.
All right. Any? Yeah, okay. Yeah.
She said, I'll deal with it.
All right. Let's see if my balance is off.
Hi, sir, how are you? Good to see you.
You're gonna get those numbers.
We are back on the record on case 2305548. I will just state that all of the attorneys that were on the record and took a break are present in the courtroom, so we don't have to go through appearances again. I asked Attorney Parrish to bring in someone who can speak to the digital discovery that I am not clear as to whether it exists or whether it is unable to be seen. So, good afternoon.
Good afternoon, ma'am.
Can you state your name for the record and your role in this case, please?
Good afternoon, Judge. My name is Purple Shannon, I'm from the Wayne County Sheriff Department. I am the OIC on this case.
Okay. Can you provide any information about the video that has been brought up from the day of first PCC regarding this case?
Yes, ma'am. There is video to this case. The video has been loaded up to evidence.com. It is to my understanding that there is an issue with retrieving that video. So at this moment, I have one of my partners bringing me that video on a flash drive, hoping that that will help defense and counsel view the video.
Have you seen the video?
Yes, ma'am.
Okay, so it does exist.
Yes, ma'am.
There's nothing wrong with the visual part of it once you get it to play,
No, ma'am, not at all.
and it's pertinent to this case, it's relevant?
Yes, ma'am.
Okay, all right, thank you very much, I appreciate
You're welcome.
it.
May I be excused?
Yes,
Thank
I
you.
might have to call you back in, but Attorney Barton, you have a question?
I do apologize. It's a question as it relates to what you were asking. What you were asking the detective, I'm sorry, I didn't.
Corporal.
Corporal, I apologize. We were told that there was no video of the incident per se. So maybe a question would be is the video that they have of the incident?
I didn't want to get into in detail, but that's why I said relevant, pertinent to the case.
I understand.
The video is pertinent to the case, Judge. Yes, ma'am.
Okay,
Thank you.
I think that's enough to have to require it to be
Thank you.
provided.
Yes, thank you. I
Any other
appreciate it.
questions from any other defense counsel regarding?
Just with that, link, that evidence.com link that was forwarded to the prosecutor's office, correct?
Yes, sir.
So are we all gonna get flash?
Okay,
At this point, I have 2 flash drives coming, Judge. One would be for the prosecutors, and then one would be for the defense counsel. There can be additional copies made of the video and provided to defense counsel. I was unaware that it was such very hard to view the video.
that's what I was just about to ask.
Yes, ma'am.
Okay, Ms. Bilkowitz, I know you've been waiting to speak.
I have done, it's not, I don't need the minutes. Okay, I just want to address the board.
I can make sense, Judge.
I had a brief question for the witness.
Yeah.
And I'm sure, the corporal, I'm sure you followed through with everything you have to do, so it's not a personal, addressing anything in that realm. When was it, I guess, when was it uploaded, if you know?
It actually has been uploaded several times. I can't give you specific dates right off the
It
top
was a
of
while
my
ago.
head. And recently, it's been uploaded when the case started. It's been uploaded 2 or 3 times in between the case started and now.
Okay,
I believe the last time it was uploaded to evidence.com was maybe a week ago.
okay, all right, thank you.
You're welcome.
Each time it was uploaded, was there some type of error? You would know.
I would not
Did you
have
receive
any, no, I did not receive any errors, sir. I do not have any knowledge as to any errors being
No problem. We just wanted to
clarifying.
clarify. Thank you very much.
No, no problem. You're welcome.
Thank you very much.
You're welcome, Judge. Maybe it's you.
Yes.
Thank you.
Okay, APA Parrish, what was the plan today, knowing that the video was not able to be seen by people?
I wasn't going to play the video, Your Honor, and if I'm being 100% honest, just now, the corporal indicating that it is relevant, that is literally not what she said to me. She said that it doesn't show or identify anybody, so the people, it would have not been of any use to the people. Our witnesses are the ones who can actually identify the defendants. This is what she told me, so I didn't know, and then on the second note, I was not aware that the discovery problem was still existing. Like I said, Council Pilkowitz has CC'd me, and each time she CC'd me, because there was other APAs that were dealing with this, Omar, Shara, and APA Kirker, they were both on it in trying to get this resolved. So I was not aware that a resolution had not taken place.
Okay, so I used to be a prosecutor, all right. If I receive discovery and I am not able to see it or view it, I think it would be my responsibility to figure it out. As the officer stating, she sent it over, so it must be some relevance, otherwise the files would be sent over. And I think that would be up to defense counsel to decide whether or not it's relevant in their defense. But if there's something that exists that was sent over to the people, and knowing today was the exam, and we've been planning this date for over a month now to get 7 attorneys in the same courtroom with 7 defendants, I don't understand why the people did not address this technical issue before today.
I know, if I may, counsel, I was assigned this case 2 days ago. However, I have been privy to the case because I am the courtroom prosecutor in here. And so I am aware of when there is issues, so I'm not making an excuse. However, you are correct. Normally I would view this, but everything that APA Kirker has indicated, we have not been able to view this. So I've been privy to this by being CC'd on it, and they have constantly told us otherwise, that we do not have the video, that the video is not relevant in the sense, and I do not disagree with you, Your Honor. Obviously, if we have it, I'm going to provide it to defense, but we did not have it. And I have been trying to.
You had it, but it's not, you can't open it.
Your Honor, I can show you what we have.
No,
And what we have is actually not a video.
The corporal just said she uploaded it previously.
It is right here. If I may finish,
The corporal just said she's uploaded.
Evidence.com reports everything.
One second, if only one person can speak.
Okay.
We have an issue here today. Let's be very clear about that with discovery as to who's responsible for why discovery has not been seen by anyone from any defense counsel.
Your Honor, as you know, evidence.com records everything. I cannot say that we don't have something or we do have something. Videos cannot be 0.1 kilobytes, and that is where it came up to be an issue. So even though, and I understand, I'm not trying to blame Corporal Mapp, even though she is indicating that it was uploaded, it was not fully uploaded. And APA Kirker has tried numerous times, and as he conveyed, they indicated that it was not able because it was too large. They should have put it maybe on a zip drive. I don't know. I'm not a tech savvy person. I know that this has been the way to resolve it in the past. But as of right now, it can be easily seen of when it was uploaded, the size of the actual video, supposedly video, it's 0.1 kilobytes.
Okay, I'm not into IT. Attorney Jaffe and then Attorney Phillips. I need to wait. Attorney Jaffe, you were trying to address the court.
Yeah, yes, Your Honor. The corporal testified just now, excuse me, she stated on the record just now that she did view the video, as she perceived that it was relevant. She also stated that it was uploaded from the outset of this case. And in terms of whether or not it was able to be accessed once it's uploaded, she didn't know, because that's not her job to see if it can be uploaded or not. That'd be the prosecutor's job. So in other words, either the corporal is not, scratch that. That's what she stated. I have no reason to think that she's being dishonest. And the fact is, it was available, and here we are today, making this request. Scratch that. Here we are, all having made this request on several occasions prior to today. I made my request per my email, at least, on the earliest day, I believe it was either February 15th or 17th. But regardless, that's where we stand. It was there, it was relevant. She uploaded it, we don't have it. So the fact that, so that's it. So bottom line, on that basis, I'll stand by my request for dismissal for not producing discovery per the statutory time frame to produce the discovery.
Ms. Phillips.
Yes, Judge, I think we should just turn it back to the law. This is a Brady issue. This is a Kyle's issue, in that any discovery, any evidence in the possession of the police is in the possession of the prosecution. That is the United States Supreme Court black letter law. This isn't complicated. It doesn't matter who had what at what time. The bottom line is, we know this video existed. We know it was in the prosecution's control. They didn't turn it over despite multiple requests. And that's the end of this matter. So as a matter of law, we can quibble over whether they were able to open their file or not, but that is irrelevant. What is relevant is the fact that the video exists, it's in the prosecutor's possession, they failed to turn it over. So let's break it down, Judge. Again, this is a straight Brady violation, but also a discovery violation. So there are two different routes the court could go to dismiss this case. Again, we're renewing our request for a dismissal at this time. My client should not be in custody, waiting around 6 weeks while the people get their act together and try and pull this video up. He is awaiting transfer to the Michigan Department of Corrections because of this single RNO count case. He is sitting in the Wayne County Jail. I've done everything to resolve this case short of an exam. That has proven to no avail. I'll get back to the germane point, Judge, for asking for a dismissal.
Your Honor, if I may, just to clarify, again, evidence.com is here. Every defense, even the court, can look at what we actually have in our possession. So stating that the people do have it in their possession is incorrect. We do not. We
So then was the corporal
absolutely
being
do not.
dishonest then when
If
he
I
said
could
that?
continue
I don't think
without
so.
being interrupted, counsel. So if the judge and the court sees it fit to dismiss, I will tell you right now, we will reissue today and everyone will be picked back up. It's just a waste of court's time because it is an inappropriate to have it dismissed because you want discovery that we truly do not have. And we are trying to resolve it. And we now have a corporal who's come in who has stated something differently than she stated before, and it is on the record, and we will oblige to, if they bring it, whatnot, we'll go forward, don't go forward, however you want to do it. But dismissing at this time, I will tell you, we will reissue this afternoon.
Ms. Perrin, did you say that you never received it or that you?
No, Your Honor, it is uploaded, as you can see on evidence.com. What is uploaded is actually not a video. So, yes, Corporal Mapp can indicate that she thinks she uploaded. It was not uploaded, a video was not uploaded, but on February 17th, they did attempt to upload some kind of file. And as I said, it is a 0.1 kilobyte file. That means there's nothing on it, essentially, Your Honor. And so we do not have a file, and that is why APA Kirker was actively trying to get this resolved and get a file. It is not that we were not wanting to, we've been actively trying to resolve this.
It is the prosecutor's duty, however. It doesn't matter who the corporal has it, right? Even if you didn't have it, Brady, the United States Supreme Court jurisprudence requires that the prosecution tender evidence that is exculpatory or inculpatory to the defense. This is not, okay, I just don't really understand the people's argument that we were not able to open the file either, so therefore we don't have to turn it over.
We can open it, but there is nothing.
We were not able to, there was
No,
nothing in
I believe that I'm gonna let everyone have their say. Attorney Bookwood, I understand your argument. I was gonna make sure everyone else has their argument on the record. Attorney Barton and then Attorney Donald.
If I may very briefly, based on what the prosecutor stated, in fact, I just wanted to point out, we're talking about construct. Is it, am I talking too low? I'm sorry, can I pull it down?
I don't mind, but everyone else, whether they mind.
Very briefly, but Madam, excuse me, Sister Counsel was talking about constructive possession. So again, Your Honor, you know this as a former prosecutor, myself as a prosecutor. Constructive possession is that the prosecutor has possession of it as long as it's through the police or agency that's bringing the charge.
Knowledge.
Correct. Now, the second thing is, Your Honor.
Well, Judge, if I may, not
Please.
knowledge. That's incorrect. That would be an incorrect statement of the law. The prosecutor doesn't even need to know about it.
But he's speaking of constructive possession.
Yes, but I just-
Requirements of knowledge. I'm just.
Oh, I'm sorry.
No, go ahead.
Okay,
I
no,
just-
no,
yep.
cut me off if you do hear any inaccuracies, I appreciate that. The second thing is, I think based on Madam Prosecutor's statement, I mean, I think if we are to dismiss, this one has to be with prejudice, Your Honor, because these young men have been, well, at least in my client's case, he was rearrested after having been released and paid a bond, and now had to continue to pay another bond. For us to be here, to not have the video that they had since day one, or did have when we're in court today and they don't even have, respectfully. And again, as a former prosecutor, I get it. I've been chasing police down to give you videos all the time. But again, that's my duty to get to the defense attorney. So with that said, Your Honor, I think if we are to even entertain a dismissal, which I think we laid the foundation for very succinctly, I think that has to be done with prejudice.
Attorney Donald.
Just briefly, Your Honor, the fact, I think it speaks volumes, the fact that the corporal is able to say, I can bring a copy here today, right now. I think speak volumes of the fact that, and I'm not saying there was lack of effort from the prosecutor's office, but the fact that the issue could be resolved by the corporal bringing a thumb drive here today, that could have been resolved several weeks ago when sister counsel here requested it. They knew that there was an issue with that, and you already have it here. The fact that we couldn't get it as defense attorneys to represent our clients, there's constitutional due process, including Brady, that it just speaks volumes, Your Honor, because if someone could have said, hey, can you bring over a thumb drive? We'll get it to the defense attorneys, we'll let them have it. The fact that we aren't able to get it here till today, Your Honor, speaks volumes.
Attorney Brown?
And yes, Your Honor, I believe, corporal testified that they uploaded this video multiple times. And if I'm not mistaken, Mr. Prosecutor indicated that, the video wasn't able to play on his laptop, if I'm not mistaken, due to some type of, not having the right format or the right codec. So that means he was knowledgeable of this particular video. And Madam Prosecutor indicated that she's not tech savvy, which could be some of the reason why they were unable to download this video from the appropriate site. Because from my understanding, it was uploaded multiple times and it was being able to be viewed. So if there was should have been a communication between the prosecutor and the corporal indicating that, okay, this video is there, this video is able to be viewed. And if it wasn't be able to be downloaded from Madam Prosecutor or Brother Prosecutor, then it should have been able to be extracted to some type of external hard drive.
Your Honor, I understand what defense is indicating. As we stated earlier in this discussion, AKA Kirker, just because I'm not tech savvy, I can do the math at 0.1 kilobytes. It's not a video. So just looking at that, but the APAs that were handling it actually brought in IT. And IT confirmed that that is not a video, and they indicated that the attempts to send something over is not able to be viewed. This was just brought up Monday. So it has been a constant
I think it's
struggle.
just poor preparation on the part of the prosecutor. I remember the first PCC, the issue was one, they received digital discovery, but it was the wrong discovery. And the response was, we will send over the correct video. Next PCC, I still don't have digital discovery. Question as to whether it existed. There was always an issue of digital. Defense counsel has been very patient with this digital discovery. I have it in my notes, digital discovery. It's not the prosecutor's office, you can't just say, oh, the video doesn't work or it's not opening, so we're just gonna go forward as a PC. It's probably cause standard. This is obviously a very important piece of evidence even for the exam stage, because it could implicate or not implicate their client. They wouldn't know because they haven't been able to view it. So I would like to dismiss this case today because I'm a little bit tired of this, not just the prosecutor's fault here in the courtroom. They are given these cases, they keep getting passed around. I keep getting emails as to who's handling, who's not handling it. They get cases the day before. I'm not giving them a crutch. But on this case specifically, we have been working on this, and I have been sending emails myself to make sure that everyone was on board for today. I've never heard the issue about not being able to open a digital video until we caught the case. I have received a jump drive from Officer Epps, who received it from the corporal, I believe.
Yes,
I handed it to Mr. Kirker. Mr. Kirker, I would love for you to speak for yourself and say what you have or observed or what you have in your hand or anything else insight-wise with this case.
I have not tried to do it yet. I tried using the flash drive to see if I can upload it onto my computer and send it over. I'm not sure if that's how it works.
You just see if you even have USB on your laptop. 'Cause I can't do it. Attorney Brown?
And with all due respect, Your Honor, I understand that some of the prosecutors may have just recently got on this case, but the prosecutor's office is Wayne County Prosecutor. They're their entire office, so we're not It's just not this particular prosecutor who's bringing the case for this entire office.
To
So
me,
any type of
never been-
inconsistency should be imputed to the whole office.
And this is not about these particular APAs.
I hear you.
This is not about these particular APAs. Again, Your Honor, I know you said you wanted to dismiss. We would like you to too. And I think we're at that stage because again, if they are aware, and again, it's not these individuals, just the office. If the office is aware that they hadn't tendered this information, they knew it wasn't available when we initiated the case. They knew it wasn't available when we reached out again. We're here at this point, and you know how hard it
At
is
the
to get
11th hour.
7 attorneys in one room. That's ridiculous at one time. So the fact that we're here and we've done everything that we had to do, at this point, I think we're now infringing upon our clients' rights. So forget our time that we've spent. We're talking about our clients and their right to a speedy trial. I think we're infringing upon.
And I received the same email, by the way, and I have proof of that on my email. After the wrong discovery was submitted, the follow-up was there actually isn't video discovery. So, and that was, in all honesty, that was like the understanding from my standpoint until like almost now-ish, so to speak, because it was never produced. But I have it in writing from the prosecutor and brother counsel referenced that as well. So.
And there are 2 defendants who have waived on this case.
So like what's going on?
If we put some teeth, some sanctions behind this, I think it'll set an example for the Wayne County prosecutor going forward that this type of behavior is not going to be tolerated at all. And they need to be on the ball.
I know Mr. Cook, you going in that.
I've said my piece, Judge. We're beating a dead horse here.
Absolutely. Very briefly, Your Honor, I'm so sorry. I have to bring this up again. My client, and I'm sure some others, this warrant came out after they were released. So we
I
had,
know, I saw the date on the.
we had to
on the
get
information.
100 or whatever the amount of bond is for this particular situation that he's in now. And then now fight another bond that was involved in this case, Your Honor. I mean, this is, they're paying, and now if they're talking about reissuing again,
I would like to just take a moment to see if Mr. Kirk can open the jump drive. That's all I want to know, if there's anything on there. I don't mean to put pressure on you, Mr. Kirk, but we just received what seems to be the golden piece of discovery.
I am trying on, this time. I use my IT help.
You need a PC, like a computer, or
I am not sure what is needed. I can see a video and I have the app that supposedly you can open it on, but. However, I mean, I could take this to the IT department and see if we can even.
I'm looking for something. Media?
because we're not clear if she handed him a jump drive picture of the puppy. We don't know, not saying that she would do so, but we don't know.
But I don't think it matters. They're still in violation of the request for 21, like, well exceeded the 21 days that we've been continuing to request. So even if they produced it at the latest hour, I think that's irrelevant. I still think it merits for dismissal request.
I think for the prosecutors in this courtroom were withholding evidence, that's the issue. I don't think they were holding on to something and not getting it. I think they were not diligent in the 0.1 millibytes or whatever that they saw and even investigating whether or not that was a problem.
Well, then judges, other than emailing them every other day for 10 days, what am I supposed to do to flag it for the prosecutor that it's their job to look at the file? So yeah, you're right. I could have come to the court. I should have. I just thought we could resolve this short of a court order or bring it to the court's attention. I thought it was a standard discovery issue, but it turned out it was not the case. So in that regard, I apologize for not raising it with the court before today, but I did email the prosecution CCing both of these individuals on all of my correspondences over the last 10 days. So any indication that we just found out about this problem in the last day or two it could not be true because I have emails dating back to March 10th, repeatedly raising this definition.
Yeah, if I may ask defense to read that rule again, because it is my understanding discovery is a a continuing process, and if she could state where in it that.
Michigan
Again,
Court Rule 6.201, subsection F, timing of discovery. Unless otherwise ordered by the court, the prosecuting attorney must comply with the requirements of this rule within 21 days of a request under this rule, and a defendant must comply within the 21 days as well. 21 days is the timing, again, our first request being on February 10th. So I believe that the final, with February having the math, I don't know.
and we provided you the discovery that we had. Granted, I'm not arguing with the fact that it is BS and it's crappy discovery. I'm not arguing that. I am though indicating that we did our part. As you stated, and I don't disagree with you. I think both sides, and I don't want to beat a dead horse, as the judge has indicated. Hopefully we can have something in here. I myself would like to get this resolved today as well. I don't want to hold it up.
The only question is whether they knew it existed, whether they knew the video.
Your Honor, the court, I have correspondence from February 21st. I reached out to the prosecutor, and initially the response was it doesn't exist. I wrote back, hi, it for sure exists because the written discovery makes several references to throughout the discovery. Response, February 21st. I will check with the OIC to see if any digital discovery exists. February 21st, in writing. I'm not throwing anyone on the bus, but like.
Could you say who it is? I know you're not throwing anyone so that we know.
No, actually, because that's, I mean, if the court would like to see it, then sure. 'Cause I'm not, like I said, I'm not trying to throw another lawyer under the bus. I don't do that. So no, actually. If the court would like to see from my phone, then I can produce
But I
it.
would like to put on the record that it was neither myself or APA Kirker that.
I think if it was you, or Mr. Herger, he would say it to your face. Is that correct?
Excuse me?
If it was either one of the attorneys here, was it either one of the attorneys? No. So, okay,
If
it was probably.
And so someone dropped the ball, and that's okay. Like, but like, let's just dismiss the case. Like, it's not. That's in the interest of justice at this point.
If I
And
may.
Your Honor, you asked a follow-up question, which I found interesting, with regard to whether they knew if the video existed. Is that the linchpin of the court's decision here, or is that what the court is weighing as to whether or not they knew the video existed? I just want to.
I understand 21 days is black and white.
Yeah,
She
well,
and then-
testified that she knew the video existed, and she tried to upload it several times.
And she did upload it several times.
I think we're talking about whether the prosecution.
Prosecutor.
Oh.
Yeah.
The prosecutor.
And Judge,
Well, there's
And
a
let me just
should-
read the court where this is discovery of information known to the prosecuting attorney. Upon request, the prosecuting attorney must provide each defendant with the following things, which would include the digital
So
discovery
if
within
they
21
read,
days.
if they read the paper discovery, it would lead them to the video discovery. Should have known we're here at the.
Your Honor, I understand. I will state that I am very well aware of Counsel Clifford's multiple requests. Therefore, I am not, at this point, I cannot argue against anything that she has stated as far as her discovery requests. She has been truthful in the fact that she has reached out. I have been truthful in the fact that we have attempted to oblige and provide whatever we have had. But I am looking through here and checking the days as you indicated. Now, that is why I was asking which prosecutor, because I do not have any discovery orders.
Kirker. And Kirker, if you would like to see my phone, and again, I'm not blaming him, but Kirker, Alexander, the prosecutor here, and the reason I'm bringing it up is because the limiting reference to Ms. Capel, the Madam Prosecutor reached out to the exclusion of everyone else, so just for the record, as an
Thank
officer of
you.
the court. With
Yeah,
all due respect,
no,
unthank
that's fine, that's fine.
you. Unthank you, actually. I mean, that's the fact. It's
All right,
honestly.
if I may finish my thought, and I
So-
appreciate you stating that because it's,
No,
I think
it was-
that all of us being forthcoming is important.
It was not the
So
right thing, it was
if-
not the right thing for me to have done that right now, so I don't agree.
Okay, well, anyways, my point being, Your Honor, obviously, these are discovery orders, do a lot, however, the court wants to proceed on to defense counsel's indication. Again, my apologies, defense and the court are correct, regardless of when I stepped into this. I do represent the people of Wayne County, and I was given misinformation in regards to the discovery. I myself was told that the video that cannot be uploaded is actual video of the jail that does not show the incident or any of the defendants, and that they would continue to try to get this video resolved, because even if it isn't relevant, or in our eyes, it is relevant to the defense, and I think everybody should be provided that. So my apologies. I feel that I should take responsibility. I'm here doing the exam, regardless if my courtroom partners or anyone else had communication. We do not have discovery. We are attempting to get it resolved. We're hoping to get it resolved today. I'd hate to get it dismissed. I'd hate to have this even adjourned, because I am not in disagreement with the fact that we have many defendants whose lives are on hold. We have witnesses outside ready to testify, and we have this court spending numerous hours, including yourself, Your Honor, organizing this. So I think we've all said our piece, and
I believe everyone has had the opportunity to put their arguments on the record.
Yes, Your
Yes,
Honor.
Judge, okay.
Very last statement, I swear, that 0.1 kilobyte, that is the notice. We have notice of the video right there. I'm sorry, thank you. I just have.
No, I agree.
It's noticed.
Okay, yeah, and I have been very aware, because there's so many defendants on this case, that there was a discovery issue from onset. After the arraignment, it was sent to me at the probable cause conference. In particular, the attorney Cook with, I remember every time you said you did not have digital discovery. I've heard from different attorneys that they did not have the right discovery. Everyone was patient. No one came to me with a request for a discovery order in an attempt to have an amicable relationship with the prosecutor, with the hopes that they would send over the proper discovery. This case was assigned to APA Intercession at one point, and then I was told it was sent to Mr. Kirker and also Ms. Parrish. That information was provided to me well before today. I will base it off of the discovery rule. It says that 21 days it should be provided. There was no request from the people to extend that 21 days for good cause, with the hopes of being able to download or find the discovery or get the issue fixed. And I do believe people had knowledge that the video existed. Between emails from whoever the other prosecutor was that said there was no video, to the courtroom saying that there was video, and she uploaded it, to the 0.1 megabytes to Mr. Kirker saying that he tried to open it but was not able to. All of this was before today. So with that, I am going to dismiss without prejudice on the basis that there's a violation of discovery and it's not provided. And it's also wasted work. So what my concern is not for you all, but the two people who weighed on this, on their case, I found the third circuit when they had the same discovery issue. But I will deal with that with that counsel. And I'm sure the prosecutor's office will chime in on it. So I'm dismissing without prejudice everyone case who is present today. That would be Mr. Burrell, Mr. Cook, Mr. Coppin, Mr. Yours is Lindsay?
Lindsay, yes.
Mr. Miller and Mr. Sutton.
Harris,
I'm sorry, Mr.
I represent some.
Oh, wait, this is your attorney, your client is Mr.
Sutton.
Sutton, yes, okay. And I will have
Thank you.
discovery for the dismissal form signed.
thank you, Your Honor.
Thank you, Your Honor.